sir.
May it please the court, Your Honor.
Yes, sir.
This is State of South Carolina versus Dae'Mon Hakeem Sanders on the defense counsel's motion to compel discovery as well as to set a bond on the charges of murder, warrant ending in 00145, for unlawful carrying, warrant ending in 00529, and warrant for possession of a weapon during the commission of violent crime, warrant ending in 00530.
All right, Mr. Hart, any particular order you want to take this up?
Your Honor, I'm fine to do the motion to compel first.
I'll let me hear from you on that.
Thank you, Your Honor, and it's pretty straightforward. When law enforcement went, this is at the Plantersville General Store. Judge, when law enforcement arrived, they got about 2 minutes and 30 seconds of camera footage. It's a camera angle within the store and a camera angle that shows the side door. Judge, that's not enough video. It's not even close to enough video. They cherry-picked what they wanted to get, and that's what they've turned over. My investigator has spoken with the manager of the Plantersville General Store. He explained those are the only 2 camera angles that could be obtained, but that he has saved in the cloud, the entirety of the footage. Whether law enforcement can obtain that or not is yet to be seen, but Judge, we are absolutely entitled to that. There was an altercation and some words exchanged about 30 minutes prior to the shooting. Additionally, after the shooting, there's a tremendous amount of footage that we feel like is relevant and necessary to get. So that 2 minutes and 30 seconds of footage is simply not enough.
Did they get the footage, or did they just?
They turned over 2 minutes and 33 seconds of footage. It's simply not enough. And we have a potential spoliation issue when it comes time for trial, because I think they had access to more and didn't obtain it.
Well, what I'm saying is you got access by subpoena. If they got it, they gotta turn it over.
Correct.
If they didn't get it, then you can get it by subpoena, just serve a subpoena on the store clerk and say, I'm subpoenaing on this.
And here's my concern, and I wanted to address that. We spoke with the manager of the store.
Right.
He tells me it is stored in the cloud, but that it recycles every 30 days. So once 30 days is up, it's gone. There's only a certain amount of storage that they can have, and that's why we need to find out if law enforcement got more than just the 2 minutes and 33 seconds. Then we have a real spoliation issue if that's all they got.
Yes, sir. This account supposedly occurred on the 22nd of September 2024. I spoke with the lead investigator on this case a month ago as well as yesterday in preparation for this particular motion. He tells me that they went in the store, they were provided with, like what defense counsel is saying, there are 2 different angles. One angle is approximately 1 minute and 22 seconds. The second angle that would show the outside curtilage of the Plantersville store was approximately 45 seconds. He tells me that this is all that was provided by the store clerk at that time. He then tells me that he doubled back a couple days later as part of the CID team, collecting all the information he could, and was told that that was all that they had. Defense counsel paints a different story, and I have no reason to doubt defense counsel's veracity. But when I'm talking to the investigators, they are telling me that they did go back in a good faith attempt to collect more video footage, and that they were not denied access to it, but were told that there was no more. And so I understand this motion to compel, but the state does not have it in its possession, nor do the agents of prosecution have it.
All right. And you have to subpoena it. And the good thing about that, you subpoena it, you get it, you don't have to turn it over to them.
Yes, sir.
So whatever it shows, you can just keep in your pocket.
I'll have my investigator follow up and see if we can get our hands on it.
All right, so I guess I'll just deny the motion to compel because based upon the fact that they say that's all, they turned over everything they had, okay?
I understand, Your Honor. Thank you.
All right.
Judge, in regards to his bond, Judge, he's now been incarcerated for 257 days. Judge, while he's been incarcerated, a lot's happened in his life. His dad has had 2 strokes. He is currently hospitalized, and Mr. Sanders is concerned his father might pass away while he's incarcerated. The birth of his first son has occurred while he was incarcerated. Judge, he is only 21 years old. He actually had a birthday back in October, so he has gone from 20 to 21 years old, being incarcerated that entire time. Judge, he has no criminal record. Judge, this is a self-defense case. We will absolutely be filing a stand your ground motion a murder charge, and surprisingly, pretty simple, pretty cut and dry. This is very much a self-defense case that we'll be fighting with the jury trial unless the senior ground motion is granted. Judge, he'll be living in Maryville with his sister. He's a lifelong resident of Plantersville. We both discussed the fact that this occurred in Plantersville. It's probably best that he not go back to that community. In regards to the danger to the community, I think ankle monitor and house arrest would entirely be appropriate. With no criminal record, that amount of time in jail, we'd actually want to consider an $80,000 bond as well as any additional requirements the court developed set on his bond.
So where would he be staying?
In Maryville with his sister.
Oh,
His
yeah.
parents are here, his mom, his stepdad, and his sister-in-law are here on his behalf. He has a lot of family support. They live in Plantersville, so obviously they'll be able to visit him, but we felt it was probably better for him to live in Maryville and not go back to that Plantersville community.
All right, what's the state's position?
Yes, Your Honor, we're standing in opposition to bond at all. We'd ask that the court deny the bond. This is, like counsel says, it is a simple case. There is video that this defendant walked in that store with an AR-style gun on him, that gun was then pulled out of his pants and shot and killed a young girl of about 16.
Mr. Sanders has turned over messages from this little girl that the state says threatening his life, threatening the life of his soon-to-be-born son, threatening the life of his parents. Judge, Mr. Sanders, and this is obviously an issue for trial, Mr. Sanders tells me they had an altercation at the store about 30 minutes prior. That's why the video was so important to us, where she flashed a weapon at him. It's our interpretation of the video. She reached for a gun at her waistband, and that was the crux of the case. Obviously, that could be an issue for the judge, the jury at an appropriate time. But Mr. Sanders was threatened with a gun previously. He was threatened through text messages. So this little girl that the state is saying, she threatened to kill him and his family.
Judge, if I may.
I'm limited to whatever change in circumstances have occurred since Judge Carricker denied bond. I find there is no change in circumstances that would justify bond, so I'm going to deny the motion.
Thank you, Your Honor.
Thank you.